Are you compliant with California's CCPA data privacy rules? Imagine running a business and not knowing if you're following the rules about how you handle people's personal information. That could lead to serious trouble. So, how do you find out if your business is on the right side of California's data privacy laws? Let's walk through what you need to know. First, the California Consumer Privacy Act applies to for-profit businesses that collect personal information from California residents. But it only kicks in if your business hits certain thresholds. If your annual gross revenue exceeds $25 million, you must comply. If you handle personal information of 100,000 or more California residents, households, or devices each year, you are also covered. Lastly, if more than half of your annual revenue comes from selling California residents' personal data, you are subject to the law. Once you know the law applies to you, the next step is to check your data collection practices. You need to review what personal information you gather, whether it's names, addresses, email addresses, or browsing habits. Your privacy policies must clearly tell consumers what data you collect, how you use it, and their rights under the law. This means updating your privacy notices regularly and making sure they are easy to understand. The law also gives consumers rights like asking to see what data you hold about them, requesting that you delete their information, and opting out of the sale of their data. You must have mechanisms in place for consumers to exercise these rights easily. For example, providing a clear "Do not sell my personal information" link on your website is essential. Starting in 2025, new rules requiring some businesses to do privacy risk assessments and cybersecurity audits. These are meant to identify vulnerabilities and improve data safety. If your business earns over $100 million annually, you need to complete a cybersecurity audit by April 1, 2028. For businesses earning between $50 million and $100 million, the deadline is April 1, 2029. Smaller businesses with under $50 million in revenue have until April 1, 2030. If you use automated decision-making technology to make important choices about consumers, you must notify them and give options starting January 1, 2027. This includes things like credit scoring or targeted advertising. Your contracts with third-party vendors and contractors must also reflect your compliance efforts. You need agreements that requiring them to follow the same data privacy rules and assist with audits and risk assessments. In the end, staying compliant means regularly checking your data practices, updating policies, and making sure your contracts support your legal obligations. If you ignore these steps, you risk fines and enforcement actions from the California Privacy Protection Agency. To keep your business on track, start with a thorough review of your data collection and storage methods. Update your privacy policies to be transparent. Prepare for upcoming audits and risk assessments based on your revenue size. Review your third-party contracts to include privacy obligations. And stay informed about any new rules or updates from the California Privacy Protection Agency. By taking these steps, you'll be better prepared to meet California's data privacy rules and protect your customers' information.